This is Department Order Number 174, Series of 2017. It contains the rules implementing Articles 106 to 109 of the Labor Code, as amended. The regulations governing contracting and subcontracting are as follows. Section 1. Guiding Principle. Non-permissible forms of contracting and subcontracting arrangements undermine the constitutional and statutory right to security of tenure of workers. Section 2. Coverage. These rules shall apply to all parties in an arrangement where employer-employee relationship exists. Contractors and subcontractors referred to in these rules are prohibited from engaging in recruitment and placement activities, as defined in Article 13b of the Labor Code, whether local or overseas employment. Section 3. Definition of terms. The following terms, as used in these rules, shall mean: A. Bond refers to the bond under Article 108 of the Labor Code, that the principal may require from the contractor, to be posted, equal to the cost of labor under contract. B. Kabu refers to a person, or group of persons, or to a labor group which, under the guise of a labor organization, cooperative or any entity, supplies workers to an employer, with or without any monetary or other consideration, whether in the capacity of an agent of the employer, or as an ostensible independent contractor. C. Contracting, or subcontracting, refers to an arrangement whereby a principal agrees to farm out to a contractor the performance or completion of a specific job or work, within a definite or predetermined period, regardless of whether such job or work is to be performed or completed within or outside the premises of the principal. D. Contractor refers to any person or entity engaged in a legitimate contracting or subcontracting arrangement, providing services for a specific job or undertaking, farmed out by principal under a service agreement. E. Contractor's employee refers to employee of the contractor, hired to perform or complete a job or work, farmed out by the principal, pursuant to a service agreement with the latter. F. In-house agency refers to a contractor, which is owned, managed, or controlled directly or indirectly by the principal, or one where the principal owns or represents any share of stock, and which operates solely or mainly for the principal. G. In-house cooperative refers to a cooperative, which is managed, or controlled directly or indirectly by the principal, or one where the principal or any of its officers owns or represents any equity or interest, and which operates solely or mainly for the principal. H. Labor-only contracting refers to arrangement where the contractor or subcontractor merely recruits, supplies or places workers to perform a job or work for a principal, and the elements enumerated in Section 5 hereunder are present. I. Principal refers to any natural or juridical entity, whether an employer or not, who puts out or farms out a job or work to a contractor. J. Service agreement refers to the contract between the principal and contractor, containing the terms and conditions governing the performance or completion of a specific job or work being farmed out, for a definite or predetermined period. K. Solidary liability refers to the liability of the principal, pursuant to the provision of Article 109 of the Labor Code, as direct employer, together with the contractor for any violation of any provision of the Labor Code. It also refers to the liability of the principal, in the same manner and extent, that he or she is liable to his or her direct employees, to the extent of the work performed under the contract, when the contractor fails to pay the wage of his or her employees, as provided in Article 106 of the Labor Code, as amended. L. Substantial capital refers to paid up capital stock or shares, at least 5 million pesos, in the case of corporations, partnerships and cooperatives. In the case of single proprietorship, a net worth of at least 5 million pesos. Section 4. Regulation of contracting or subcontracting. The Secretary of Labor and Employment shall regulate contracting and subcontracting arrangement, by absolutely prohibiting labor-only contracting, and restricting job contracting allowed under the provisions of the Labor Code, as amended. Section 5. Absolute prohibition against labor-only contracting. Labor-only contracting, which is totally prohibited, refers to an arrangement where a. 1. The contractor or subcontractor does not have substantial capital, or 2. The contractor or subcontractor does not have investments, in the form of tools, equipment, machineries, supervision, work premises, among others. And 3. The contractors or subcontractors' employees recruited and placed, are performing activities which are directly related to the main business operation of the principal. Or b. The contractor or subcontractor does not exercise the right to control over the performance of the work of the employee. Section 6. Other illicit forms of employment arrangements. In addition to Section 5 of these rules, the following are hereby declared prohibited, for being contrary to the law or public policy. A. When the principal farms out work to a kabu. B. Contracting out of job or work through an in-house agency. C. Contracting out of job or work, through an in-house cooperative, which merely supplies workers to the principal. D. Contracting out of a job or work, by reason of a strike or lockout, whether actual or imminent. E. Contracting out of a job or work, being performed by union members, and such will interfere with, restrain or coerce employees, in the exercise of their rights to self-organization as provided in Article 259 of the Labor Code, as amended. F. Requiring the contractors or subcontractors' employees, to perform functions, which are currently being performed by the regular employees of the principal. G. Requiring the contractors or subcontractors' employees to sign, as a precondition to employment or continued employment, an antedated resignation letter, a blank payroll, a waiver of labor standards, including minimum wages and social or welfare benefits, or a quitclaim releasing the principal or contractor from liability as to payment of future claims, or require the employee to become member of a cooperative. H. Repeated hiring by the contractor or subcontractor of employees, under an employment contract of short duration. I. Requiring employees under contracting or subcontracting arrangement, to sign a contract, fixing the period of employment to a term shorter than the term of the service agreement, unless the contract is divisible into phases, for which substantially different skills are required, and this is made known to the employee at the time of engagement. J. Such other practices, schemes or employment arrangements, designed to circumvent the right of workers to security of tenure. Section 7. When principal is deemed the direct employer of the contractors or subcontractors' employees. In the event that there is a finding, that the contractor or subcontractor, is engaged in labor-only contracting under Section 5, and other illicit forms of employment arrangements under Section 6 of these rules, the principal shall be deemed the direct employer of the contractors or subcontractors' employees. Section 8. Permissible contracting or subcontracting arrangements. Notwithstanding Sections 5 and 6 hereof, contracting or subcontracting shall only be allowed, if all the following circumstances concur. A. The contractor or subcontractor is engaged in a distinct and independent business, and undertakes to perform the job or work on its own responsibility, according to its own manner and method. B. The contractor or subcontractor has substantial capital, to carry out the job farmed out by the principal, on his account, manner and method, investment in the form of tools, equipment, machinery and supervision. C. In performing the work farmed out, the contractor or subcontractor is free from the control and/or direction of the principal, in all matters connected with the performance of the work, except as to the result thereto. And D. The service agreement ensures compliance with all the rights and benefits for all the employees of the contractor or subcontractor under the labor laws. Section 9. Solidary liability. In the event of violation of any provision of the Labor Code, including the failure to pay wages, there exists a solidary liability, on the part of the principal and the contractor, for purposes of enforcing the provisions of the Labor Code and other social legislations, to the extent of the work performed under the employment contract. Section 10. Rights of contractors or subcontractors' employees. All contractors or subcontractors' employees shall be entitled to security of tenure, and all the rights and privileges as provided for in the Labor Code, as amended, to include the following. A. Safe and healthful working conditions. B. Labor standards, such as but not limited to, service incentive leave, rest days, overtime pay, holiday pay, 13th month pay, and separation pay. C. Retirement benefits under the SSS, or retirement plans of the contractor or subcontractor. D. Social Security and welfare benefits, and E. Self-organization, collective bargaining and peaceful concerted activities including the right to strike. Section 11. Required contracts under these rules. A. Employment contract between the contractor or subcontractor and its employees. Notwithstanding any oral or written stipulations to the contrary, the contract between the contractor or subcontractor and its employees shall be governed by the provisions of Articles 294 and 295 of the Labor Code, as amended, including the provisions on general labor standards. It shall include the following stipulations. 1. The specific description of the job, or work to be performed by the employee, and 2. The place of work, and terms and condition of employment, including a statement of the wage rate applicable to the individual employee. The contractor or subcontractor shall inform the employee of the foregoing stipulations in writing, on or before the first day of his or her employment. B. Service agreement between the principal and the contractor. The service agreement shall include the following. 1. The specific description of the job or work being subcontracted, including its term or duration. 2. The place, or work, and terms and conditions governing the contracting arrangement, to include the agreed amount of the contracted job or work, as well as the standard administrative fee of not less than 10% of the total contract cost. And 3. A provision on the issuance of the bond or bonds as defined in Section 3A, renewable every year. Section 12. Effective violation of the provisions on the rights of contractors' employees, and required contracts. A finding of violation of either Sections 10 or 11 hereof, shall render the principal, the direct employer of the employees of the contractor or subcontractor, pursuant to Article 109 of the Labor Code, as amended. Section 13. Effective termination of employment. The termination of employment of the contractor's or subcontractor's employee prior to the expiration of the service agreement, shall be governed by Articles 297, 298 and 299 of the Labor Code. In case the termination of employment is caused by the pre-termination of the service agreement not due to authorized causes under Article 298, the right of the contractor's or subcontractor's employee to unpaid wages and other unpaid benefits, including unremitted legal mandatory contributions, such as SSS, PhilHealth, PUG-EBIG, ECC, shall be borne by the party at fault, without prejudice to the solidary liability of the parties to the service agreement. Where the termination results from the expiration of the service agreement, or from the completion of the phase of the job or work for which the employee is engaged, the latter may opt to wait for reemployment within 3 months, to resign and transfer to another contractor employer. Failure of the contractor to provide new employment for the employee, shall entitle the latter to payment of separation benefits, as may be provided by law or the service agreement, whichever is higher, without prejudice to his or her entitlement to completion bonuses or other emoluments, including retirement benefits whenever applicable. The mere expiration of the service agreement shall not be deemed as a termination of employment of the contractors or subcontractors' employees, who are regular employees of the latter. Section 14. Mandatory registration and registry of legitimate contractors. Consistent with the authority of the Secretary of Labor and Employment, to restrict or prohibit the contracting out of labor, to protect the rights of workers, it shall be mandatory for all persons or entities acting as contractors, to register with the Regional Office of the Department of Labor and Employment or DOLE, where it principally operates. Failure to register shall give rise to the presumption that the contractor is engaged in labor-only contracting. Accordingly, the registration system, governing contracting arrangements, and implemented by the regional offices of the DOLE is hereby established, with the Bureau of Working Conditions or BWC as the central registry. Section 15. Requirements for registration. The verified application for registration as a contractor shall be filed at the DOLE regional office, in the region where it seeks to principally operate. Whenever applicable, the applicant shall provide in the application form the following information. A. The name and business address of the applicant, and the areas where it seeks to operate. B. The names and addresses of officers, if the applicant is a corporation, partnership, cooperative or a labor organization. C. The nature of the applicant's business, and the industry or industries where the applicant seeks to operate. D. The number of regular workers, and the total workforce. E. The list of clients, if any, the number of personnel assigned to each client, if any, and the services provided to the client. F. The description of the phases of the contract, including the number of employees covered in each phase, where appropriate, and G. Proof of compliance with substantial capital requirement as defined in Section 3L of these rules. The application shall be supported by A. A certified true copy of a certificate of registration of firm or business name, from the Securities and Exchange Commission or SEC, Department of Trade and Industry or DTI, Cooperative Development Authority or CDA, or from the DOLE if the applicant is a labor organization. B. A certified true copy of the license or business permit, issued by the local government unit or units where the contractor operates. C. A certified listing, with proof of ownership or lease contract, of facilities, tools, equipment, premises implements, machineries and work premises, that are actually and directly used by the contractor, in the performance or completion of the specific job or work contracted out. In addition, the applicant shall submit a photo of the office building and premises, where it holds office. D. A copy of audited financial statements, if the applicant is a corporation, partnership, cooperative or a labor organization, or a copy of the latest ITR if the applicant is a sole proprietorship. And E. A sworn disclosure, that the registrant, its officers and owners or principal stockholders or any one of them, has not been operating, or previously operating as a contractor under a different business name or entity, or with pending cases of violations of these rules and or labor standards, or with a cancelled registration. In case any of the foregoing has a pending case, a copy of the complaint, and the latest status of the case, shall be attached. Section 16. Filing and processing of application. The application, with all supporting documents, shall be filed in triplicate, in the regional office where the applicant principally operates. No application for registration shall be accepted, unless all the requirements in the preceding section are complied with. Section 17. Verification inspection. Within 2 working days upon receipt of the application with complete supporting documents, the authorized representative of the regional director shall conduct a verification inspection on the facilities, tools, equipment, and work premises of the applicant. Section 18. Approval or denial of the application. The regional office shall deny or approve the application, within 3 working days after the verification inspection. Applications that fail to meet the requirements set forth in Section 15 of these rules, shall be denied. Section 19. Registration fee. Payment of registration fee of 100,000 pesos, shall be required upon approval of the application. Upon registration, the regional office shall return 1 set of the duly stamped application documents to the applicant, and retain 1 set for its file, and transmit the remaining set to the Bureau of Working Conditions or BWC within 5 days from registration. Section 20. Validity of Certificate of Registration. The contractor shall be deemed registered only, on the date of issuance of its Certificate of Registration. The Certificate of Registration shall be effective for 2 years, unless cancelled after due process. The same shall be valid in the region where it is registered. In case the contractor has service agreements, or operates outside the jurisdiction of the regional office where it is registered, it shall request a duly authenticated copy of its Certificate of Registration, from the registering regional office, and submit the same to the Dolly regional office where it seeks to operate, together with a copy of its service agreement or agreements in the area, for purposes of monitoring compliance with these rules. Section 21. Renewal of Registration. All registered contractors shall apply for renewal of their certificates of registration 30 days before the expiration of their registration, to remain in the roster of legitimate service contractors. The applicant shall pay a registration renewal fee of 100,000 pesos to the Dolly regional office. Copies of all the updated supporting documents in letters A, 2, E, of Section 15 hereof, shall be attached to the duly accomplished application form, including the following. A. Certificate of Membership and Proof of Payment of SSS, PhilHealth, BIR, ECC and PUG-EB contributions for the last 3 years, as well as loan amortization, and B. Certificate of Pending, or No Pending Labor Standards Violation Case or cases with the National Labor Relations Commission or NLRC, and Department of Labor and Employment or Dolly. The pendency of a case will not prejudice the renewal of the registration, unless there is a finding of violation of labor standards by the Dolly Regional Director. Section 22. Semi-annual reporting. The contractor shall submit in triplicate its subscribed semi-annual report, using a prescribed form to appropriate regional office. The report shall include A. A list of contracts entered with the principal during the subject reporting period. B. The number of workers covered by each contract with the principal. C. Proof of payment of the Social Security System, the PUG-EB Fund, PhilHealth, Employees Compensation Commission, and Bureau of Internal Revenue remittances due its employees during the subject reporting period, and of amortization of declared loans due from its employees, and D. A certified list of all cases, filed against the contractor before the NLRC and Dolly. The regional office shall return 1 set of the duly stamped report to the contractor, retain one set for its file, and transmit the remaining set to the BWC within 5 days from receipt thereof. Section 23. Grounds for cancellation of registration. The Regional Director shall, upon a verified complaint, cancel or revoke the registration of a contractor after due process, based on any of the following grounds. A. Misrepresentation of facts in the application. B. Submission of falsified, or tampered application or supporting documents to the application for registration. C. Non-submission of service agreement between the principal and the contractor, when required to do so. D. Non-submission of the required semi-annual report as provided in Section 22 on semi-annual reporting thereof. E. Final findings that the contractor has engaged in labor-only contracting and, or other illicit forms of employment arrangements as provided in Section 6 hereof. F. Non-compliance with labor standards and working conditions. G. Findings of violation of Section 10 on rights of contractors' employees, and Section 11 on required contracts. H. Non-compliance with SSS, the HDMF, PUG-EBIG, PhilHealth, and ECC laws. I. Collecting any fees, not authorized by law and other applicable rules and regulations, and J. Violations of any provisions of the Labor Code. Section 24. Due process in cancellation of registration. Complaint or complaints based on any of the grounds enumerated in the preceding section against the contractor, shall be filed in writing and under oath, with the regional office which issued the certificate of registration. The complaint or complaints shall state the following. A. The name or names and address, or addresses of the complainant or complainants. B. Name and address of the contractor. C. The grounds. D. When and where the action complained of happened. E. The amount of claim if any, and F. The relief sought. Upon receipt of the complaint, the Regional Director shall direct, with notice to the complainant, to file a verified answer or counter affidavit, within 7 working days without extension, incorporating therein all pertinent documents in support of his or her defense, with proof of service of a copy to the complainant. Failure to file an answer or counter affidavit, shall constitute a waiver on the part of the respondent. No motion to dismiss shall be entertained. The Regional Director or his or her duly authorized representative, may conduct a clarificatory hearing, within 7 calendar days within which to file a verified answer or counter affidavit. Within the said 7 calendar days period, the contractor shall make necessary corrections or rectifications on the violations that are immediately rectifiable, upon its initiative in order to be fully compliant. The Regional Director may avail himself of all reasonable means, to ascertain the facts of the case, including conduct of inspection, where appropriate, and examination of informed persons. The proceedings before the Regional Office, shall be summary in nature. The conduct of hearings, shall be terminated within 10 calendar days from the first scheduled clarificatory hearing. The Regional Director shall resolve the case, within 7 working days from the date of the last hearing. If there is no necessity to conduct a hearing, the case shall be resolved within 7 working days from receipt of the verified answer or counter affidavit. Any motion for reconsideration from the order of the Regional Director, shall be treated as an appeal. Section 25. Appeal. The order of the Regional Director, is appealable to the Secretary, within 10 working days from receipt of the copy of the order. The appeal shall be filed with the Regional Office, which issued the cancellation order. The Office of the Secretary, shall have 30 working days from receipt of the records of the case, to resolve the appeal. The decision of the Secretary, shall be final and executory after 10 days from the receipt thereof by the parties. No motion for reconsideration of the decision, shall be entertained. Section 26. Effects of cancellation of registration. A final order of cancellation, shall divest the contractor of its legitimate status to contracting or subcontracting. Such order of cancellation, shall be a ground to deny registration and application for renewal of registration to a contractor under the rules. No contractor whose registration is cancelled under these rules, or any of its officers, shall be allowed to operate, and apply for new registration as contractor under either the same or different name. The cancellation of the registration of the contractor, for engaging in labor-only contracting, or for violation of any of the provisions of these rules involving a particular service agreement, will not, however, impair the validity of existing legitimate job contracting arrangements the contractor may have entered into with other principal, prior to the cancellation of its registration. Any valid and subsisting service agreement, shall be respected until its expiration. Thereafter, contracting with a delisted contractor, shall make the principal direct employer of all employees under the service agreement pursuant to Articles 106 and 109 of the Labor Code, as amended. Section 27. Retaliatory measures. Pursuant to Article 118 of the Labor Code, as amended, it shall be unlawful for the principal, contractor, or any party privy to the contract or services provided, to refuse to pay or reduce the wages and benefits, and discharge, or in any manner discriminate against any worker who has filed any complaint, or instituted any proceeding on wages under Title II, Book 3 of the Labor Code, labor standards violation, or has testified or is about to testify in such proceedings. Section 28. Enforcement of labor standards and working conditions. Consistent with Article 120A of the Labor Code, as amended, the Regional Director through his or her duly authorized representatives, shall conduct routine inspection of establishments engaged in contracting arrangement, regardless of the number of employees engaged by the principal or by the contractor. They shall have access to employers' records and premises, at any time of the day or night, whenever work is being undertaken therein, and the right to copy therefrom, to question any employee and investigate any fact, condition or matter which may be necessary to determine violations, or which may aid in the enforcement of the Labor Code and of any labor law, wage order, or rules and regulations issued pursuant thereto. The findings of the duly authorized representative, shall be referred to the Regional Director for appropriate action, as provided for in Article 128, and shall be furnished the collective bargaining agent, if any. Based on the visitorial and enforcement power of the Secretary of Labor and Employment in Article 128A, B, C, and D, the Regional Director shall issue compliance orders to give effect to the labor standards provisions of the Labor Code, other labor legislation, and these rules. Section 29. Duty to produce copy of contract between the principal and the contractor. The principal or the contractor, shall be under an obligation, to produce a copy of the service agreement in the ordinary course of inspection. The contractor shall likewise be under an obligation, to produce a copy of any contract of employment, when directed to do so by the Regional Office Director or his or her authorized representative. Section 30. Tripartite implementation and monitoring of compliance. A region-based tripartite monitoring team, on the observance of labor standards in contracting and subcontracting arrangements, shall be constituted, as a subcommittee of the Regional Tripartite Industrial Peace Council or RTIPC, within 15 days from the effectivity of these rules. It shall submit a quarterly regional monitoring report to the DOLE Secretary, and to the National Tripartite Industrial Peace Council or NTIPC. The Bureau of Working Conditions or BWC, shall ensure the implementation of this provision, and shall conduct capacity building to the members of the Regional Tripartite Monitoring Team. Section 31. Financial Relief Program. Tripartite Co-Regulation Engagement. A financial relief program, or unemployment assistance fund, shall be established for employees under a service agreement, or employees in transition from one service agreement to the next. For this purpose, the National Tripartite Industrial Peace Council or NTIPC, upon the effectivity of this issuance, shall constitute a local service provider tripartite working group, LSPTWG, composed of representatives of the stakeholders in the industry. The LSPTWG shall A. Recommend the mechanics and details, in setting up the financial relief program or unemployment assistance fund, with proposed funding sources before end of June 2018, and B. Draw up the terms of a tripartite co-regulation engagement, in ensuring full compliance with labor laws, for approval or endorsement by the NTIPC, including a proposed table of progressive rate of increases in the minimum capitalization requirement at reasonable intervals, to ensure that only legitimate contractors can engage in subcontracting arrangement. Section 32. Enrollment in DOLE programs on improving compliance with labor standards. For purposes of ensuring compliance with labor standards, the principal and subcontractors covered by these rules are mandatorily required to enroll and participate in the DOLE programs, such as the Incentivizing Compliance Program under Department Order No. 115-11. Section 33. Contracting or subcontracting in the construction and other industries. Contracting or subcontracting arrangements in the construction industry, under the licensing coverage of the Philippine Construction Accreditation Board or PCAB, shall not be covered by the provisions of these rules, and shall continue to be governed by Department Order No. 19, Series of 1993, on guidelines governing the employment of workers in the construction industry, and Department Order No. 13, Series of 1998 on guidelines governing the occupational safety and health in the construction industry. And DOLE D.PWHDILGDTI and PCAB Memorandum of Agreement, Joint Administrative Order No. 1, Series of 2011 on coordination and harmonization of policies and programs on occupational safety and health in the construction industry. In industries covered by a separate regulation of the DOLE or other government agency, contracting therein shall be governed by these rules, unless expressly provided otherwise. Section 34. Prohibition on DOLE officials or employees. Any official or employee of the DOLE or its attached agencies, is prohibited from engaging, or having any interest in any contracting or subcontracting business. Section 35. Supersession. All rules and regulations issued by the Secretary of Labor and Employment, inconsistent with the provision of these rules, are hereby superseded. Section 36. Separability Clause. If any provision or portion of these rules are declared void or unconstitutional, the remaining portions or provisions hereof shall continue to be valid and effective. Section 37. Effectivity. This department order shall be effective 15 days after completion of its publication in a newspaper of general circulation. Issued in Manila, Philippines, on March 16, 2017.